Say a pleasant good evening to attorney at Law Joseph Sookoo. Good evening, sir.
Good evening, Mr. Koo.
Yes.
Nice to be on your show again.
Yes, it's a pleasure to have you. And let me say Happy New Year and, of course, best of health to you, great health, financial prosperity, and a peace of mind for 2024, you and your family.
And, of course, the same to you, yours, your friends and family, and to our viewers as well.
Thank you. Now, last time we were speaking about the rental arrangements, tenants, landlords, and many people weighed in and said they want to thank you for that because it seems that a lot of things that happen where people engage in contractual arrangements, they simply lack the clarity. And I think people just sign on the dotted line with the hopes that none of those clauses or none of those things that are mentioned may never occur. But too many times that's not the reality. Things do come up. And when it comes up, it becomes sometimes a legal hassle. Of course, we're looking at a contractor. I'm not going to call the name now, but we are looking at this contractor, that, of course, from East Trinidad. And this was basically to build the construction of a superstructure for 8-unit apartments, including rendering, door frames, window frames, roofing, painting and decorating, floor, wall, and ceiling finishes. So basically from A to Z, that's it, from foundation to finish. Now there was a contract period, and I guess this dealt with the duration of works, the commencement of the job, and when the completion of it was expected. Variations of the contract. The client reserves the right to vary the contract during the period of this contract, and it is only the client that can change the work details of this contract. And as well as termination of contract. The client can terminate this contract for one or more of the following reasons: if the contractor is absent regularly in the performance of his contractual obligations and what have you. Now, an effective termination on compensation. In the event that the client terminates the contract, he will be obligated to pay the sums due to the contractor for that part of the work completed, and in the event the contractor terminates the contract, the client will be obligated to pay for the works executed. Now, that's clear. It's basically all that I'm reading here clear, right?
Yes, I follow what you're saying. It's, unfortunately, when we talk about the law and these sort of contracts, I fear that in my experience, and based on what you're describing, these contracts are, in my view, sadly lacking. They are vague. They are very basic, perhaps maybe for the parties to understand, because, true construction contracts are actually quite detailed. For example, the last aspect you described, that is, if the contract is terminated by the client or by the contractor, monies would be due and or payable relative to the value of the works done. I mean, all of that is a simple way of saying quantum meruit, which is a legal principle that essentially sets out that a party is entitled to obtain the value of his works. But look at the vague aspect of it. Look at how it's not properly set out. How does one determine the value of the works? Who determines it? Right? Are there processes within the construction contract or within the construction process itself that allow for an assessment of the value as it goes along? Now, you find all of these terms being imported into big contracts. The multi-million, multi-billion-dollar contracts, because you know what? There are a suite of legal contracts, a suite of legal terms that have been generated over the years, since the 50s, that are normally imported into contracts like this. Most lawyers know it as FIDIC contracts. Most people who deal in construction know what FIDIC contracts are. And in particular, for contracts of, I believe the FIDIC body recommends for under $500,000 US dollars, or up to $3 million, $3.5 million, you can use what they call the Green Book contracts, which set out everything you need and how you get those things done.
Oh, so there's a right way and there's a perfect way.
There's a right way, there's a perfect way, and there's a lazy way.
Okay.
And when you start getting lazy, well, problems often arise.
And sometimes these contracts are drawn up without having any input from a professional, a legal professional. And it's drawn up between two parties thinking, well, all right, this is binding, this is good. And I think for whatever reason, I think that's the lazy part you're talking about. But when all is said and done, this contractor is simply saying, listen, yeah, I may have made a mess of things. I didn't deliver. but I have no money now to return and rectify any of the problems that have occurred. So you are out. If you have a problem, send me a legal letter. And it seems as though when people say send me a legal letter, they're all prepared and have the knowledge firsthand that this is going to be a long, drawn-out hassle. And if you think it's worth it, then catch me if you can. Tell me.
Well, you see that catch me if you can thing? That's almost exactly right. But I'll get to that shortly. In terms of the long drawn-out process, you're right. If someone dares you to sue them, then really that's the only place you go. Depending on the contractor, of course, there are potentially other opportunities on the contract, but generally, you sue. Now, in recent years, and I normally don't hold my punches, but I give Jack his jacket when, that is due. The Judiciary of Trinidad and Tobago has been reinforcing the ranks of judges, and with doing that, one expects that the timeline for the completion of cases will shrink. In recent times, it's gone up to anywhere between 2 to 3 years, but I would hope within the next 5 years or so, we could perhaps bring that down to half of that. So there is some time involved, yes. And the law also involves that before you even sue, you engage in pre-action correspondence. But that correspondence very often leads to, well, sue me if you dare. Now, as regards the catch me if you can scenario, which one presumes means, well, trying to find money, trying to get blood from a stone, well, unfortunately, that's again, it falls to the laziness aspect, the due diligence aspect. Because ultimately, and I don't like phrasing it this way, but if you're going to do business with someone that you don't know their financial background, that you don't know their history in construction, that you don't know to have a reputation of quality, or even a history of business, you're essentially buying cat and bag. You don't know whether this is the person's first job or last. You don't know whether or not there are guarantees of quality. And in a lot of government contracts, which of course you don't find in the private sector, right, the government often requires bonds to be paid in the event of non-performance, so that there's money waiting in the event that you don't comply or you don't do a good job. That, as I said, is not available in the private sector. And frankly, it's going to be difficult to force that. But how any person can get past that or minimize their risk is simply doing their homework. I would hate to say that this means deal with the bigger contractors, but they are probably bigger contractors for a reason.
Yeah, I understand your point quite clearly. I mean, you have to do your homework. You really and truly need to do your background check because, it's one thing that you have one guy who thinks he can weld up 50 gates before Christmas, and when Christmas morning comes, those gates are just simply leaning against the wall, and he's gone, compared to someone who's supposed to build an entire building, 8 units, from A to Z, and when things don't work out, just simply say, listen, I know I made a mess, but I have no money to fix anything. I can't at this time. So, I guess basically it means that shortcuts lead to heartache and headache, as the case may be. But
right.
Again, what can we do to protect ourselves? Because many people from the time they hear, well, listen, you have to take the legal route. You got to go get an attorney. You got to go to court. Hey, that will take some time. That in itself is a turnoff. But yet still, there has to be something to protect consumers.
Well, you see, okay, let's look at it in 2 ways. Prevention, an ounce of prevention better than a pound of cure. So the first thing we're looking at, what can you do from the very beginning to prevent things going awry at the end? First thing first, and it might sound self-serving, if you're going to spend $2, $3, $5 million, spend a couple thousand and go to an attorney and have them, do the due diligence. Let them review the contract, let them make recommendations, let them advise certain things that you want in there. Look into the contracts, because, everyone does contracts for all number of things, and certainly building houses and superstructures, there's always a contract involved, whether it's a 1-page or 2-page. In fact, to tell you how amusing some things are, I reviewed a contract last year where the contractor spelt Richter, as in Richter scale, wrongly. It was amusing. But the point is, review your contracts first. Put in your safeties at the beginning. Look at your contractors. And if you can negotiate certain things, you negotiate it from the very beginning. Now, this steps back to the whole category if you can thing. Certain contractors are limited liability companies. There are remedies in the event of obtaining judgments or even the threat of obtaining judgments against these companies that can force the operating parties of those companies into circumstances where they can't operate that company or any other company again. If you drive a company into bankruptcy due to unpaid judgment debts, it affects the abilities of those parties who ran that company to run other companies. It's not exactly the greatest element here, but the ability to do further business, badly or otherwise,
is hindered.
Yeah, it's hindered, and that's something you can look at. So look at the nature of the company you're dealing with. After the fact, now, if you're caught on the wrong side of things, well, unfortunately, again, it's back to being lazy. You can't get blood from a stone. If you've gotten yourself caught up with the wrong parties, and you go to court, you get a judgment, it may be a sole trader pretending to be something bigger. He has nothing remaining. There's not much you can actually do except register your judgment and wait forever, if at all, to get back your money.
All right. And let me ask you, in this case, because you viewed these documents, is there a case? As you can also see, money was spent to rectify with another contractor. Can that money, of course, also, can we go after as far as what was spent, what was messed up by the first contractor?
Well, I'll be very careful to say this now. I am not offering legal advice. Although I can't do that. But
right.
If indeed in a circumstance where a contractor has failed to perform his duty pursuant to the contract, in that he either has failed to live up to, and this is taken from recent judgments, by the way, the implied duty of fit workmanship. In other words, it doesn't have to be in the contract, but the moment a contractor says, I'm going to build something for you, the law implies duties that it has to be built properly. Equally, if that duty is breached, which is part of the contract, or alternatively, if that duty is breached because of negligence in performing those duties, so it's two different sides of the same coin, the party then has the remedy to go after them and seek damages. Now, in this particular case, or rather in the circumstance that you've described, how does one prove damages? There are multiple ways. And in this particular case, the damage would be the cost of rectification, which can be proven by the evidence of the party who did the rectification. That person may want to be brought in as an expert to speak about how they can estimate that value and then charge that value, or alternatively, depending on the level of resistance at the litigation stage, you can simply put in the invoices and recover that as your damages.
All right. All right. So the bottom line is, Mr. Sookoo, don't be lazy. Pursue. Go after it. It was your money. It's jumping up. And you need to have this redress as far as rectified in your favor.
Yes. Ultimately, from step one, if you're going to spend that kind of money, be a little safe. You're going to buy a used car, do your searches. You're going to buy a piece of property, do your searches. Make sure title is good. You're going to spend $3 million on a property, on building something. Well, make sure that the people you're dealing with are reputable, and make sure that in the event something goes wrong, there's a strong possibility, whether because this company has assets, you can get that from looking at company records. You can even derive that from, other searches.
Yeah.
But make sure that the party can, in the event that they default, have the means to pay you.
I agree. Well, that's it for us this evening. I want to thank you so much again enlightening us. I mean, it really makes you wonder sometimes that there are people out there who just feel as though they're just helpless. There's nothing they can do. But I think that if you really sit down and you start to go through things, because again, it's your money. And it doesn't matter what people may think, that you're being miserable, you're being whatever. Listen, you better deal with it now, because down the road it's going to cost you an arm and a leg. So please, people, do your homework. Thank you again, Mr. Sookoo. Keep up the good work and best of luck to you and your entire team. And again, have a wonderful new year. And when these issues arise, you're our go-to man right here on The Observer. Thanks so much.
Thank you, Mr. Kerr. Nice speaking to you again.
Thank you.